Hello, my name is Melissa Adams. I'm a member of the Nisga'a Nation and an archivist, and I grew up on the territories of the Musqueam, Tsleil-Waututh, and Squamish nations. I'll be reading to you today from the Truth and Reconciliation Report section entitled The TRC Seeks Full Access to LAC Records. LAC is Library and Archives Canada. It begins on page 304 and ends on page 307. The TRC seeks full access to LAC records. Schedule N to the Indian Residential School Settlement Agreement describes the mandate of the TRC, as well as the obligations of the parties to the agreement to assist the Commission in its work. There is a provision that deals with the obligation of the parties to provide relevant records to the Commission. It states, in order to ensure the efficacy of the truth and reconciliation process, Canada and the churches will provide all relevant documents in their possession or control to and for the use of the Truth and the Reconciliation Commission, subject to the privacy interests of an individual as provided by applicable privacy legislation, and subject to and in compliance with applicable privacy and access to information legislation, and except for those documents for which solicitor-client privilege applies and is asserted, in cases where privacy interests of an individual exist, and subject to and in compliance with applicable privacy legislation and access to information legislation, researchers for the Commission shall have access to the documents provided privacy is protected. In cases where solicitor-client privilege is asserted, the asserting party will provide a list of all documents for which the privilege is claimed. Canada and the churches are not required to give up possession of their original documents to the Commission. They are required to compile all relevant documents in an organized manner for review by the Commission and to provide access to their archives for the Commission to carry out its mandate. Provision of documents does not require provision of original documents. Originals or true copies may be provided, or originals may be provided temporarily for copying purposes if the original documents are not to be housed with the Commission. Insofar as agreed to by the individuals affected and as permitted by process requirements, information from the Independent Assessment Process, IAP, existing litigation, and dispute resolution processes may be transferred to the Commission for research and archiving purposes. Gaining access to archival government records about the administration of the residential school system has been an important part of the mandate of the Truth and Reconciliation Commission of Canada. Such access has been essential for our own understanding of the history of government policy and practice in relation to Aboriginal peoples in general and residential schools in particular. But it has also been necessary to fulfilling our mandated obligation to ensure ongoing public access to records through the National Centre for Truth and Reconciliation. The Commission's attempts to obtain records were frustrated by a series of bureaucratic and legal roadblocks. In April 2012, the Commission was compelled to file a request for direction in the Ontario Superior Court of Justice regarding access to relevant federal records housed in the National Archives. At issue was the question of what Canada's obligations were under the settlement agreement with respect to providing the TRC archived government documents housed at Library and Archives Canada. The Commission, Aboriginal Affairs and Northern Development Canada, the Department of Justice, and Library and Archives Canada had very different views as to how the TRC should acquire these records. In LAC's view, its role was that of the neutral keeper of government records, whose task was to facilitate and empower federal government departments to canvass their own archival holdings. Faced with the onerous task of conducting its own research through LAC's vast holdings. Canada's position was that its obligation was limited to searching and producing relevant documents from the active and semi-active files in various departments. The government's view became that the departments need provide the TRC only with departmental researcher status to access their archive documents at LAC, so that the Commission could conduct its own research. The TRC's position was that Canada was obligated to produce all relevant documents, including those at LAC, and had an additional obligation to provide the Commission with access to LAC in order to conduct its own research. Although the TRC, in the spirit of cooperation, had agreed to obtain departmental researcher status, it maintained that this was unnecessary because the settlement agreement already gave the Commission unconditional access to the archives. The end result was that Canada had effectively shifted the onus of its responsibility to produce LAC documents onto the TRC. In rendering his decision in favor of the Commission, Justice Stephen Googe ruled, "In my view, the first paragraph of Section 11 sets out Canada's basic obligation concerning documents in its possession or control. The plain meaning of the language is straightforward. It is to provide all relevant documents to the TRC. The obligation is in unqualified language, unlimited by where the documents are located within the Government of Canada. Nor is the obligation limited to the documents assembled by Canada for production in the underlying litigation, paragraph 69. I therefore conclude that given their meaning, the language in Section 11 of Schedule N does not exclude documents archived at LAC from Canada's obligation to the TRC. The context in which the settlement agreement was created provides further important support for that conclusion in several ways, paragraph 71. First, telling the history of Indian residential schools was clearly seen as a central aspect of the mandate of the TRC when the settlement agreement was made. Since Canada played a vital role in the IRS, Indian Residential School system, Canada's documents, wherever they were held, would have been understood as a very important historical resource for this purpose, paragraph 72. Second, the settlement agreement charged the TRC with compiling an historical record of the IRS system to be accessible to the public in the future. Here, too, Canada's documents, wherever housed, would have been seen to be vital to this task, paragraph 73. Third, the story of the history and the historical record to be compiled over 100 years, over 100 years and dates back to the 19th century. In light of this time span, it would have been understood at the time of the settlement agreement that much of the relevant documentary record in Canada's possession would have been archived in LAC and would no longer have been in the active or semi-active files of the departments of the Government of Canada, paragraph 74. Fourth, it would have been obvious that the experienced staff at LAC would have vastly more ability to identify and organize the relevant documents at LAC than would the newly hired staff of the newly formed TRC. It would have made little sense to give that task to the latter rather than the former, particularly given its importance to the TRC's mandate, paragraph 75. Although the difficulties the TRC encountered in obtaining LAC documents were specific to the Commission's mandate, they highlight broader questions concerning the role of state archives and archivists in providing documents that reveal the facts of why and how a targeted group of people have suffered harms on a massive scale. As part of a growing trend towards demanding better government accountability and transparency, and the evolution of new privacy and freedom of information legislation, archives have become more directly connected to the struggles for human rights and justice.